either because he or she can't prove the elements of the claim, or he or she has been on it, workers' compensation, for quite some time and has just exhausted himself or herself of the process. Or number two, if the employer has gotten sick of paying the claim and would like to wrap it up in a lump sum, or if the employer is just going to cave in, and instead of caving in and paying benefits, they work out a settlement with the claimant. In either of those two scenarios, whether it's employer-driven or employee-driven, that's when a settlement occurs. But there are cautions. You don't want to settle a case if you shouldn't settle a case, and there's lots of reasons to settle, and there's lots of reasons not to settle.
When the settlement occurs, how long does it take to actually get your money?
Well, once the settlement occurs, it has to get approved by a judge. And to get approved by a judge, you have a special hearing that approves something called a compromise and release agreement. And what happens is the judge will schedule a hearing, you'll have the hearing, the judge will usually approve it right then and there, and if the employee waives his or her right to an appeal, and the employer does the same, the employer has 30 days from the date of that hearing to pay that settlement. Many times the employer won't waive its right to an appeal, and therefore it's 30 days from the date that the judge circulates the order approving the settlement.
Okay, we're going to talk. We're going to talk about how your line of work and mine intersect and what that intersection looks like. You can give us a call at 215-227-2727. I'm Dean Weitzman. I'm my Philly lawyer, and I'm here in the studio with my friend Jeff Gross, and we're talking workers' compensation. Let's talk to Audrey from Overbrook. Hi, Audrey. Welcome to Court Radio.
Good morning. How are you?
I'm well, thanks. You have a question for Jeff?
Yes. I got injured at work. I hurt my knee. They gave me a series of injections. I'm back to work now. I'm thinking about leaving my employer, going to another job. Now, if something happens with my knee later on, because they did tell me, the orthopedic doctor told me that I might need more shots 6 months from now, a year from now. He said it varies. If I have a problem related to a work-related injury and I leave that employer, what do I do? I mean, are they still responsible for me?
Well, you're going to be having some major problems, because if you go to a different employer and your knee acts up again and you make a workers' compensation claim against the old employer, since that's where you got hurt, which is what you would think, right?
Mm-hmm.
Then what ends up happening is that first employer will say, oh, no, this is an aggravation of what we had accepted as a work injury because of the job duties of the new employer. And it's because of her work at the new employer that's causing this aggravation. It must be the new employer's fault. And the new employer is going to defend by saying, oh, no. This is the responsibility of the original employer because she did not fully recover when she came to our employment, and therefore it's got to be their fault. So the two employers are going to point fingers at each other, which is going to leave you in the middle. Right. Which is why you want to have a lawyer, because there are certain things that can be done in order to expedite your benefit. And one of the things that can be done is something called a Section 410 order, which is new to many listeners here because nobody really knows the codes or the sections of the Workers' Compact. But a Section 410 order is where the judge says, all right, both employers are pointing their finger at each other, and it's clear that the claimant cannot perform her job and is in need of medical attention for the work injury, because we don't know whose responsibility it is right now until we get medical testimony, rather than leave the claimant hanging, waiting for all that to ensue, which could be about a year and a half. We're going to allow both employers, or the judge is going to order both employers to split the liability and pay each 1/2 of the disability or the medical benefit until there's a determination as to whose fault this really is, whether it's the old employer or the new employer. That way you don't get left holding,
Okay. Now, what act is that? You just named an act under the workers' comp law?
It's a Section 410 order.
215-227.
Thank you very much.
You're welcome.
You. 215-227-2727. We are providing answers to legal questions. And if you need representation for a workers' comp case, all you got to do is give us a call, and Jeff will get on the case immediately. 215-227-2727. The last caller reminded me about another area of workers' comp, and there are so many where people they just don't understand their rights. In this day and age, a lot of folks work multiple jobs. They're working one job. It's not quite full time. They're working maybe, 25 or 30 hours a week. It's their main squeeze. And then they've got a couple little side things going on, and to kind of help fill in the gaps financially. While they're working at their main place, they're injured. Bada boom. They fall down. Injuries occur in so many ways. It could be a repetitive task, like Jeff talked about, where you develop a condition from repetitively doing something like traditionally a butcher would develop carpal tunnel, a wrist injury from whacking the meat over and over again, or whatever, like the pharmacist who's opening bottles over and over. They get injured in their main job, but it's not their full source of income. How do they make up these other jobs? And if that injury is preventing them from doing any of their jobs, do they only get paid from the one?
That's a great question, Dean. And the answer is there is something called concurrent employment, which is what you just talked about, where you have multiple jobs at the same time concurrently. And in a concurrent employment situation, what happens is the time of injury employer, meaning where you got hurt at work, wherever that employment is, that employer is actually responsible for your disability related to all your employment. So if you can do the other two jobs that you have, it's no big deal. The only workers' compensation benefit you will get is from the injury, the time of injury employer. But if you can't do those other jobs, then the time of injury employer has to pay for both of those jobs, or 4 of those jobs, or however many jobs you have. It doesn't matter. So when they calculate your benefit rate, they take into consideration all of your employment and all of the earnings that you have in the time that you are working, and then you develop an average weekly wage with a corresponding wage rate subject to all of that employment. So it actually helps you if you have multiple positions and jobs and in different employers. The time of injury employer is responsible for all of them.
See that now, come on, folks, if you're injured at work, do you think that the folks who are quote unquote helping you from your employer or the employer's carrier are going to give you that information and provide you with the necessary paperwork so that you get paid from job B, C, and D while you're working for job A? Of course not. They're not going to mention anything about that, and you're going to be really in a situation where you're not being compensated the way you were used to being compensated, which will put the pressure on you and force you before you're ready to go back to work. And that's really the goal. That's the goal. That's the end game of your employer's carrier. Get you back to work ASAP, regardless of your physical condition.
That's right. That way they don't have to pay you.
It couldn't be any more simple than that. Give us a call at 215-227-2727. But unfortunately, we must pay the bills here, so we're going to take a quick break to honor our sponsors.
For 20 years, Center City Medical Center has provided premium expert medical services for Philadelphia. Whether you need musculoskeletal rehab or an immigration physical, call 888-945-EXAM. Our board-certified physicians have more than 80 years' experience from post-injury rehab to DNA paternity testing. To make an appointment at one of our 3 convenient locations, call 888-945-EXAM. Get premium expert care. Center City Medical Center, serving Northeast, North, and Center City, Philadelphia. If you've been injured on the job and are entitled to workers' comp, you need someone fighting for you from the start. Call Jeffrey Gross, attorney at law. Don't rely on your employer or insurance company to get it right. Call 215-512-1500. If you're entitled to workers' comp or it's being challenged, Jeffrey Gross can help get the money you deserve, and he won't get paid unless you get paid. Call 215-512-1500. Jeffrey Gross, attorney at law, representing Pennsylvania's injured workers for more than 20 years.
You were just hurt. It's not your fault. You're in physical pain. How do you get better? Who is going to help you recover? West Philadelphia Associates has highly trained doctors and staff that can help you today. Don't wait at a hospital. West Philadelphia Associates will work with your attorney, providing documentation of all injuries and the best plan for treatment to get you back to the life you deserve. With diagnostic studies to better detect injuries, West Philadelphia Associates doctors and staff will help you recover. West Philadelphia Associates, here to help you get better because you deserve it. Call 215-471-4714.
If you have legal problems and need answers, call My Philly lawyer, Dean Weitzman, first at 215-227-2727 for personal injury, medical malpractice, birth injury, and more. Call Dean first.
He will fight for your rights. That's what Dean Weitzman is all about.
Call My Philly lawyer, Dean Weitzman, first. 215-227-2727. My Philly lawyer, when winning matters most.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's More Court Radio with your host, Dean Weitzman.
Whoa, whoa, whoa. Welcome back. I'm Dean Weitzman, and this is Court Radio, your 1 hour of legal entertainment, your opportunity to ask legal questions one at a time and get an answer for free. Ha 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 ha. Yeah. Want to know how many of my competitors are giving free information? That's right. Crickets. None. But I get up every Sunday morning and have some fun with my Court Radio listeners. All you got to do is give us a call at 215-227-2727. The only number you need in your Rolodex or your cell phone Rolodex.
People don't have Rolodexes anymore.
Yeah, I know. It's just being coy. 215-227-2727. We are talking to Jeffrey Scott Gross, Esquire, the man who does workers' comp. How did you get into this? Give me a thumbnail of that.
Real quickly, my grandfather was the hero.
Grandpop who?
Pop Bob.
Pop Bob, and he was your hero.
He was my hero. He was an assembly line worker for 40 years, worked for Bond Bread, which is a defunct baking company. And,
I remember them.
Okay, and he baked bread, and he worked from midnight to 8 a.m., 40 hours a week for 40 years, and it was a very, very tough life. And when I graduated law school, he said to me, don't work for the big, giant employers. Stand up for the little guy. They're the ones that need your help. And he saw a lot of bad things happen when he was working on an assembly line, and he actually helped a woman who got her hair caught in the assembly line process and got the whole scalp pulled off of her head. So he put that scalp back on her head and picked her up and took her to his car, and she bled all over the place. Took her to Einstein Hospital.
I thought he was taking her right to your office.
No, not to my office. I wasn't born yet. Took her to the hospital. They sewed her scalp back on, saved her.
Wow.
Yeah.
Pop Bob.
Pop Bob, my hero.
215-227-2727. Let's talk to Karen from West Oak Lane on line 3. Hi, Karen, and welcome to Court Radio.
Hi, how you doing? Good morning. It's a pleasure talking to you guys. This year, at my job, I was doing care with a patient, and I hurt my back. I went to physical therapy. They sent me to their doctor, and I was doing physical therapy, and they put me back to work to do light duties, and I was doing that, like, doing paperwork and stuff like that. And then I got sick in June, so I had to stop physical therapy. So I was out like for 3 months, and I went back to work. I went to my doctor, and she cleared me to go back to work. But it's not for with the physical therapy. It's with another sickness that I had. So I still haven't completed the physical therapy, and now I'm wearing a brace with my back because my back is acting up.
And what's your question?
I did not. I was wondering because I did not file for what you call it?
Workers' compensation?
Workers' comp, right? Because I thought that if I did, they would fire me, and then I wouldn't, have a job. So that's why I didn't file, because I'm scared.
But okay, you're scared to file, but you're still injured. You still have the original injury, and that injury is curtailing your ability to do your job, preventing you from doing your job. What is it?
Yes. Oh no. I mean, even this morning, I was really aching bad. It doesn't go away.
So here's the problem. If you don't notify your employer that you're having problems, they're going to use that against you. And they're going to basically deny the claim when you go ahead and try to assert a claim. However, if you notify them immediately, then you are perfecting your right to file a workers' compensation claim.
Let me ask you a question. Her fear is a justified fear that probably a lot of my listeners have.
Yes.
If I notify my employer, they're going to find a reason to can me. So you go before a judge. The employee who's been a stellar employee is fired after reporting a claim. What's the judge in most workers' comp cases going to do?
Grant that claim and find the employer, the actions are very, very egregious. And let me tell you something else. You might have another claim, because if they terminate your employment after you file a workers' compensation claim for no other reason, then basically you can sue the employer for a wrongful termination claim.
There you go. So, look, you have some rights. You have some power. Do not feel compelled to keep quiet about your workers' comp injury, because if you do, you really play into the employer's hands. They're playing off your fear. They're hoping you won't do anything, because as time goes by, you won't be able to do anything.
Right. And if you are still scared about doing something, the least you can do is just contact me, and I can talk to you about it, because I can steer you straight, even if you're scared. Someone's got to be on your side.
Somebody has to be on your side. Yeah.
Being scared of filing that, because I don't want to be out of a job, and having children, to take care of.
Understood. Totally understood. Give us a call during the week at 215-227-2727. We'll put you in touch with Jeff. We'll bring you in. We'll discuss your claim. We'll get all of the details about your claim, and Jeff will be able to give you a thoughtful answer, and maybe tell you to go back to work, or maybe tell you, nope, it's time to go see this doctor or that doctor who's a specialist in the field with whom Jeff has long-standing relationships.
Okay.
All right. Thanks for calling Court Radio. Have a great Sunday. And wonderful questions you had about workers' compensation. Let's talk to Michael on line 5 from Glen Olden, who's got a workers' comp question. Hi, Michael.
Hi, good morning.
Good morning to you. Where is Glen Olden?
Delaware County.
Delaware County. Okay. Close to Chester County or close to Philly?
No, closer to Philadelphia, between Darby and Ridley Township.
Near McDade Boulevard.
Yep.
There you go. Jeff knows everything. Do you know that Jeff flies planes? Yeah.
It's true. I am a geography nut.
And he's been known to fly to workers' comp hearings in other parts of the state.
It's true. I have.
This guy's crazy. Not only that, but he gives his cell phone number out to every client he has.
It's true.
I
believe in servicing the client.
Yeah. And that really is why Jeff and I are friends, because, you know, his ability to service clients makes me look good. And that's, you know, I don't want to be affiliated with people. I don't want my brand, my Philly Lawyer, affiliated with people who don't do their job.
That's what you call a symbiotic relationship.
All right, let's stop this now before we get too far. Michael, you had a question.
Yeah.
What's your question?
So I'm a veteran of the United States Coast Guard, and I have a service-connected disability that I've been rated at 30%. I've tried to have that increased and have had very little luck because all of the doctors who are seeing me are VA doctors. Does that fall, or can it fall under the same sort of ways that you would go about with a normal workman's comp claim?
That's a very, very good question. Now, what you have, because you are a federal employee, right?
No longer.
Right, but you were when you had the injury. So
Yes.
Because you were a federal employee, you fit under the federal employment workers' compensation, not state workers' compensation. There's a difference. So federal employees do not have the same type of protection that the Pennsylvania state, Pennsylvania employees that are governed under the state of Pennsylvania have. So you have to actually get help from using the federal government as your help. But if you give a call, we can certainly help you with that.
Okay.
And
thanks. I appreciate the insight.
Okay, no problem. Thank you so much for calling. The number to call is 215-227-2727. That'll get you an appointment in the office and a conversation with an attorney who specializes in the area in which you have a question.
At no charge.
Of course, no charge. The only time we charge any fees, well, other than domestic relations, wills and estates, but I mean, on workers' comp and injury cases, the only time we charge a fee is when we've actually gotten money for our client. Now, I promised folks we would talk about the intersection of our two areas, so I just want to briefly lay out something here. Jeff and I represent a fellow who lives in Maine, and this person was injured while he was in his employment. The injury occurred as a result of a motor vehicle accident. So he's driving for his employer, and there's a collision with a third party. Now, folks, you cannot sue your employer. You cannot collect for your pain and suffering, for future pain and suffering from your employer. You've given that right up in the Commonwealth of Pennsylvania under the Act. But you do not have to prove that it wasn't your fault either. So when Jeffrey goes forward on a workers' comp case, he proves only one thing, and that is that you have a work-related injury that prevents you from doing your job. Okay? I, as an attorney who represents people who are involved in accidents, have to prove a second thing. Not only do I have to prove did that accident cause an injury, but I have to prove that the accident was not your fault, that the accident, whether it's a trip and fall on a defect or a motor vehicle accident, was the fault of another. Sometimes Jeff and I represent individuals who have been involved in an accident, and I'm suing a third party who caused the accident, and Jeff is representing the client on a workers' comp case because the injury occurred while the employee was working. Jeff, you just settled that case.
I did.
And you got the employee. First of all, your work enabled that employee to be paid over a period of time of about 3 years.
That's right.
So the employee is being paid each day over the last 3 years, and then it culminates in a lump sum settlement.
Right.
Okay. And then I, representing the employee on the third-party case, take Jeff's work because the employee or the employer is entitled to subrogation. What is that?
Subrogation means that the employer can actually get some of their money back that they've laid out, meaning both the wage loss benefits that they've paid this guy over the course of the last 3 years, as well as all the medical bills, including surgery and physical therapy and medication that they have paid out as well. And when you add all that up, and then you further add the lump sum that we settled his case for future disability, that amounts to a tidy sum. And that amount would be, they don't get it dollar for dollar, but they do get a percentage of their money back from the settlement that you make on the third-party claim.
And so in this case, Jeff's settlement and all of the benefits paid to Jeff's client and mine, it amounts to something over $200,000.
More than that, way more than that.
Okay. And so when I make a settlement on the third-party case, the guy who caused this accident or the woman who caused this accident, their insurance company has to pay for my client's pain and suffering and this large sum of money that we will end up funneling back to the carrier who represented the employer. So ultimately, folks, if there is a third-party case, okay, then the employer gets the money back that they've been paying you.
And what many people don't realize is that the pain and suffering element, otherwise known as non-economic damages because it's not out of pocket, in addition to the wage loss and the medical benefits, that can be had against the third party. And when you add all that together, that's a lot of money.
Yeah.
The workers' compensation portion that the employer gets back has an amount, but that is a factor in determining the total amount of the value of the claim with the third party.
There's a lot of complexities, the bottom line, as we wrap up. There's a lot of complexities in the law with regard to workers' compensation, how it interplays with the other portions of your accident claim. And the only way, the only way to be truly protected and to get what you're owed is to have proper legal representation. And so, folks, if you've got a workers' compensation claim that you've been engaged in and you've been unrepresented, it's time to pick up the phone this week and give us a call at 215-227-2727. I'll see you in the office this week. So will Jeff. Have a great week, and thanks for listening to Court Radio and Jeffrey S. Gross, Esquire. Thanks for participating as a sponsor and a friend.
Thank you.
All right, folks. Bye-bye.
The preceding was a paid program of MyPhillyLawyer.com.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Good morning. Court Radio is now in session. Call 215-227-2727. When you've got legal questions, we've got the answers. This is Court Radio. And now here's your host, Dean Weitzman.
Good morning and welcome back to Court Radio. It's Sunday, October the 25th. That's right, the last Sunday in October. And this is Court Radio. I want to thank our Court Radio listeners. You know, I haven't said it enough. We're number 2 in the entire Philadelphia metropolitan marketplace. Number 2, right behind a news show that will remain unnamed. But I aspire for the number 1 spot. So Court Radio listeners, talk to your friends and family. Tell them what's happening over here on the dial on Sunday mornings at 7 o'clock and get them to give us a call with their legal questions. So, you know, I have a special guest host today. You know him. He's always advertising on Court Radio. It's the one, the only, Jeffrey M. Gross, Esquire.
Good morning.
Dude, when Jeff's here, you know we're talking about workers' compensation. That's right, workers' comp. If you have been sitting on a workers' comp question, you know, I was injured at work, what do I do? Or I think I might be injured at work and I don't know how to open a claim or how to get that going. Today's the day to ask those questions, because I got to tell you, there is no one in Philadelphia who has forgotten more, who knows more, who is more passionate about workers' comp than my friend Jeff.
Thank you, Dean. That's very kind of you.
But I speak the truth. So we're going to get to workers' comp. We're going to take folks' questions about any legal issues, but if you have a workers' comp question, certainly today is the day to ask it. 215-227-2727. That's all you got to do. And you give us a call, you'll get into Court Radio. During the week, that number, 215-227-2727, gets you into My Philly Lawyer, where you'll be treated like a king or queen with your legal issues. Just give us a call. So, Jeff, things are happening around. Also, one last thing, little housekeeping. I want to thank everybody who came out yesterday for the Bread of Life Luncheon. The annual Bread of Life Luncheon, which I MC, is more fun on a Saturday morning/afternoon than you can imagine. If you haven't seen praise dancing, you haven't lived. That's the truth. All right, well, I felt God yesterday, and I know the other 300 people who were there did as well. And we had a lot of fun and raised a lot of money for a good cause. So there you go. Now you'll have to wait till next year, next October, to come to the Bread of Life Luncheon. And speaking of the Bread of Life, we have a workers' comp question on line 3. We got Bob from Sharon Hill. Bob?
Hey, good morning.
Good morning.
Good morning.
What's happening? What's happening in Sharon Hill? It's a little drizzly out there, Bob. Be careful. Wear a little jacket and make sure you bring your bumbershoot.
Oh, yes, I will. Yes, I will.
Okay. All right. Bumbershoot. I was hoping I was going to get to use bumbershoot today.
What is a bumbershoot?
Come
What
on.
is a bumbershoot?
Come on. You know what a bumbershoot is. It's an umbrella. It's an umbrella. All right.
I never used an umbrella in my life.
I got to tell you something, Bob. I think it's a man thing. I don't usually use an umbrella either. I find it's more difficult to open the thing and then to close the thing, and then you get wet. At some point, you're going to get wet. So I just feel like, heck with it, and I just go running, dashing down the street without an umbrella. But think about this. Now, if you had to take a long walk in a heavy rain, you would probably need to have an umbrella, or at least maybe today's newspaper or something to put over your head.
Stay in one spot.
Wait, and that one spot has no rain.
No rain. Right in your car with the windshield wipers on.
There you go. All right, Robert. So you got a workers' comp question, don't you?
Yes, sir.
All right. What is it?
How come when you try to apply for workman's comp, number one, you have to have representation. You have to have a lawyer. Number two, do the lawyer get any proceeds out of your workman's comp?
Okay, that's it. That's a two-part question, which normally would be a violation of the Court Radio rules, one question per person. But I'm going to allow this as a two-part, sub-part A and B. Go for it, Jeff.
Yes, I can answer that question, Bob. First of all, you don't have to have representation, but if you don't have representation, you are at a major, major disadvantage. The problem is that the Workers' Compensation Act is very, very complicated. It's not required by law to have a lawyer. You can always proceed by yourself. But because of the complexity of the Workers' Compensation Act, you really need to have somebody that's versed in it in order to beat out your opponent who is versed in workers' compensation law and does have representation, which would be your employer and its insurance carrier. Because you are a person who doesn't deal with workers' compensation all the time, you are not going to know the ins and outs of the procedure, let alone the law itself, as far as what you need to prove to the judge to win your claim. So even if you have a very, very good claim and you are totally disabled and it's totally apparent to anybody, it's not necessarily a win situation because there are intricacies of the law that you won't know and procedures which you won't be able to follow because you won't know them either. The second part of your question was, does the lawyer get any part of the proceeds of your claim? Typically, the law permits a 20% fee, which would be 20% contingent upon a successful recovery of your claim. So that if you do not win or prevail in your claim, the lawyer would get nothing. But if you do win, then there is a 20% fee of those benefits. That, in that way, you are really never out of pocket any money because you are being helped and you will prevail in a way that's very minimalistic in terms of your outlay of money.
You know, I always feel like folks who pay a fee for legal representation should I want to make sure that my client is getting far more with my taking my piece of the case, my fee, far more than they would be getting if they were not represented by me. And they were represented by themselves, let's say, with regards to the insurance company. And I usually feel at the end of representation, not always, but I usually feel at the end of representation that it was worth it for my client, that they actually get more. Even though they're paying me, they get more than they would had they been unrepresented. The only exception to that rule is if you, in my area of the law, if you have a catastrophic injury and there's only a very small policy, then pretty much no matter what happens, you're going to get that policy with or without my representation. If you've got, surgery, fractures, your catastrophic injuries, and there's only a $15,000 policy, in that case, usually you're going to get that.
Right, and in workers' compensation, there is no such thing as policy limits. You can get workers' compensation until the day you die. So, I mean, you could, multiple years of benefits you could be getting, including medical benefits on top of that. The problem is that most people, like I said, don't know the procedure, but the lawyers, and especially me, I happen to know who I'm dealing with. I know the players, I know the judges, I know who they are, I know all the defense attorneys, and I have relationships with them so that they respect my work and they respect my integrity in the system. And, if I take a case, it's usually a case that's going to win.
Bob, thanks for calling us from Sharon Hill.
Yeah, but can
Yes.
I say one thing?
Yep.
Mm-hmm. But I'm going to say this. God help you if you go without a lawyer.
Yeah.
Because they give you so much trouble trying to get workman's comp. It's a shame.
And not only that, and thanks, Bob, and have a great Sunday. It's always good to hear you. But, the other thing is that folks don't know how to start this. And that's really important because I find I get a lot of calls from people who say, hey, 7 months ago, I was in an accident at work. I was injured. The employer sent me to a doctor. I saw the doctor one time. The doctor told me everything will get better. And I've kind of suffered through a long period of injury. And my employer then fired me 6 months later because I wasn't able to do the job that I thought that I used to be able to do. Now, Dean, can you help me? Now, at that point, you're 6 months behind the kind of the pendulum. And you've been working for 6 months, albeit in pain and with discomfort and not at the same level. What happens in cases like that, Jeff?
Well, Dean, you're absolutely right. In fact, most of the time, the Act permits the employer to designate its own doctors for the first 90 days of treatment. And if you are going to a doctor for the employer and that doctor is hell-bent on getting you back to work, whether you are ready or not, that doctor will do so. And if you don't have an attorney who knows the intricacies of the system, who knows how to get around that 90-day rule and knows how to get around you having to see the employer's physician, then you're at a loss, because after all that time expires, the question's going to be, why didn't you see a doctor? Why are you not back to work? Or if you are back to work and you're fired, that's the reason why you're not working, not because you are disabled. So it really puts you at a disadvantage.
So the answer is that you need to report it early, you need to report it often, and you need to do what with regard to the doctor who isn't really your advocate in this situation?
Right. You need to continue to go to the doctor even after they discharge you, meaning the doctor for the employer. And what I can do is I can get around that scenario, because there are it's a very, very narrow instance where it actually applies. In many times, the employer doesn't properly perfect its right to have you see their doctors. And if you can't point that out to the judge and you can't point that out to the employer, people just cave in and they go to that doctor anyway.
215-227-2727. Let's take line 4 with my mom, Lil. Yo, Lil, how are you? Are you surviving after yesterday's lunch?
Yes, my son, and you always do a perfect job. I want to thank you, and I just want people to let everyone to know that I won't call you my baby name. I always call you, but
thanks.
I just want everyone to know that when we first became Bread of Life Foundation, we didn't have a lot of income. And I would call Dean up and tell him, this person need money for medicine, this person need money. And he would say, okay, I'm going to send you a check. And for a couple of years, he paid for people medicine for me. And that was a blessing. He still gives. He makes sure that he gets a table, that his staff comes. And he knows I'm going to Marion Caters this week, so I'll text you or call you and tell you the date.
For next year. Let me ask you a question.
I just want to tell you, your staff, thank you for them coming. Thank you for all you do. And it's really a blessing. And he's not just my Philly lawyer. He's Bread of Life lawyer, and he's always there to give money. And he doesn't ask any questions. He just say how much you need. That person needs to get medicine. I just can't explain what a kind heart he has. And
okay, whoa. I got to jump in here. I got to just ask you one question, because Bread of Life Foundation provides support for those who are injured with illnesses. And provides financial support, provides faith-based support. Let me just ask you one question. How do people get in touch with the Bread of Life Foundation?
Oh, they call 609, because we're in Jersey, but we help everybody in Philly and all over, 609-871-0606.
All right. I love you. Thanks for... No, I got to go. You got to go.
Okay, baby. Thank you for everything.
All right. Take care. Bye-bye. 215-227-2727. Let's go to line 3. That would be Jesse from South Philly. Hello, Jesse.
Yes, how you doing? Good morning.
Good morning. I'm so happy we got you on. You've got a great radio voice.
Oh, thank you.
Uh-huh. Got a future in radio. What happened, Jesse? You have a workers' comp question for my friend Jeff?
Yes. I work in a hospital, and I was working for transportation, and I had a problem with my left side, my arm, and they said I needed an operation, and they performed, relieved the pressure in the back of my neck. And I went to do the recovery, but I used my own time. And I was wondering, should I have workman's compensation instead of using my own sick time?
Well, Jesse, let me ask you a question. Is this a work-related injury that you had, or a non-work-related injury?
I I think work and work related, because in transportation you're using your arms and your back and your legs, and you're pushing wheelchairs or stretchers.
Okay, so number one, if it's a work-related injury, you would need to report that immediately to your supervisor, and you would need treatment from a doctor who could say that it is work-related. And once you determine that it is work-related by a medical doctor, then what you can do is you can make a workers' compensation claim. So you have 3 years to do that. You have 120 days, that's 4 months, to tell your employer that you had a work injury, but you should do that immediately, and then you have 3 years to actually file the claim. So there's two different things there. But once that's done, your sick time, or your time as you put it, should be restored once there's a successful comp claim. So if you want to use if you want to put this onto workers' compensation, you would need to have a successful claim. So I would ask that you contact me offline, and my number is 215-512-1500. You can give me a call anytime once we're finished with this, and I can help you personally with that.
Okay, there you go. Thank you so much, Jesse, for calling from South Philly, and have a great Sunday. 215-227-2727. If you've got legal questions for Jeff, give him a call. We're here in the studio. We'll be right back after these announcements.
For 20 years, Center City Medical Center has provided premium expert medical services for Philadelphia. Whether you need musculoskeletal rehab or an immigration physical, call 888-945-EXAM. Our board-certified physicians have more than 80 years' experience from post-injury rehab to DNA paternity testing. To make an appointment at one of our 3 convenient locations, call 888-945-EXAM. Get premium expert care. Center City Medical Center, serving Northeast, North, and Center City, Philadelphia. If you've been injured on the job and are entitled to workers' comp, you need someone fighting for you from the start. Call Jeffrey Gross, attorney at law. Don't rely on your employer or insurance company to get it right. Call 215-512-1500. If you're entitled to workers' comp or it's being challenged, Jeffrey Gross can help get the money you deserve, and he won't get paid unless you get paid. Call 215-512-1500. Jeffrey Gross, attorney at law, representing Pennsylvania's injured workers for more than 20 years.
You were just hurt. It's not your fault. You're in physical pain. How do you get better? Who is going to help you recover? West Philadelphia Associates has highly trained doctors and staff that can help you today. Don't wait at a hospital. West Philadelphia Associates will work with your attorney, providing documentation of all injuries and the best plan for treatment to get you back to the life you deserve. With diagnostic studies to better detect injuries, West Philadelphia Associates doctors and staff will help you recover. West Philadelphia Associates, here to help you get better because you deserve it. Call 215-471-4714.
If you have legal problems and need answers, call My Philly Lawyer, Dean Weitzman, first at 215-227-2727 for personal injury, medical malpractice, birth injury, and more. Call Dean first.
He will fight for your rights. That's what Dean Weitzman is all about.
Call My Philly Lawyer, Dean Weitzman, first. 215-227-2727. My Philly Lawyer, when winning matters most.
The following is a paid program brought to you by My Philly Lawyer. The views and opinions expressed are those of the sponsor and do not necessarily reflect the views and opinions of the station and its management.
Need more legal answers? Here's more Court Radio with your host, Dean Weitzman.
Good morning and welcome back. It's Dean Weitzman, and this is Court Radio. If you've got legal questions, we've probably got the answer. All you need to do is give us a call at 215-227-2727. Ba-boom. Yes. Everything is well here in Philly. It's October the 25th, a little drizzly outside, about 55 degrees. If you're going out today, you might want to wear a little raincoat and bring your bumper chute with you. That's right, a bumper chute.
That's a new term for me.
Yeah. That's that disemboweled voice is the one, the only Jeffrey M. Gross, Esquire. Oh, I'm sorry. It is Jeffrey S. Gross.
Yes.
You know what? I was thinking about that other co-host who had a middle initial with the M. It's David M.
I gotcha.
Yeah. Sorry, Jeffrey.
No worries.
And S stands for Stanton.
No. S
Steven.
stands for Scott.
Scott. Okay. There you go. Jeff is a workers' comp lawyer who works with My Philly Lawyer on all of our workers' comp cases. Folks, if you've got a workers' comp claim, if you think you might have a workers' comp claim, by all means, give us a call today with your questions. But if for some reason you don't get through, you can always get us at 215-227-2727 during the week. And we've got a workers' comp question from, with, by, and from David from West Philly. I haven't heard from anybody, David, in West Philly in so long, I can't even tell you.
Good morning. How are you?
I'm well, thank you. Are you driving?
My daughter has she worked as a pharmacy tech and one of the local hospitals here, and she came down with carpal tunnel in her two hands. And I was telling her, matter of fact, the pain got so bad she had to leave her job. And they gave her some type of treatment, but I told her, you needed to talk with a lawyer. She's terminated her employment with the hospital. But is it still possible for her to reach out to a lawyer to get some directions on which way to go to put a claim in?
David, this is Jeff Gross. I'm going to respond to your question. The answer is yes. First of all, doing whatever she is doing, if it's a cumulative trauma type of situation where she's using her hands over and over and over and over and over again, like twisting and pulling or doing something with her hands, like putting on caps of bottles for prescription medications, for instance, the answer is yes. She could very well have a workers' compensation claim because it could be certainly aggravated. Her condition could be aggravated or caused by a work-related duty that she has to perform. So she should call a workers' compensation attorney like me as soon as possible, because there is a time limitation on providing notice to the employer, as well as a time limitation on filing a claim. I spoke to the gentleman last who called, and I explained that it's a 120-day time limitation to provide notice to your employer, but you should do it immediately anyway. And there's a 3-year statute of limitations to file a claim. So the fact that she has terminated her employment with this hospital is going to set her back a bit, so she would need to speak to me immediately if she could. Time is of the essence.
Okay, fantastic.
All right, David, thanks for giving us a call, and thanks for being a loving, caring father.
What number do we reach you during the week?
215-227-2727.
Oh, the same number. Fantastic. Thank you so much.
You're very welcome. So let's talk to Leslie on line 2 from North Philly, bouncing around Philly. Hello, Leslie, and welcome to Court Radio.
Hi, how are y'all this morning?
We're doing well, thanks, and thanks for your patience as you held on the line so nicely.
That's okay. Thank you. I wanted to ask a question. There's two different people, one Delaware it happened in and one in Scranton. How do you go about getting felonies removed off you, like expunged or something?
Well, I'm afraid to tell you, Leslie, that there is no expungement in the Commonwealth of Pennsylvania for any felony convictions. If you've been convicted of a felony, that stays on your record for life.
Okay.
And that even applies at this moment to misdemeanors. Even little old misdemeanors in Pennsylvania are never expungible. But we're working with some guys in Harrisburg who promised me this year There's going to be a law passed, which is the beginning of a livable expungement law. But it will not include felonies. Even the new law will not include felonies. And we'll just have to wait and see. But right now, the answer is no can do, Leslie from North Philly.
All right. Thank you. Have a good day.
You do as well. 215-227-2727. That's the number to call with all your legal problems. Call My Philly Lawyer. Let's talk to Rachel from North Philly on line 5. Hi, Rachel. Welcome to Court Radio.
Thank you.
Is this your first time calling?
Yes, it is.
Have you been stalking Court Radio, listening to us?
I've been listening and not really knowing if I wanted to ask a question. But today, a gentleman made a comment to the gentleman, and I just wanted to see if there was something in reference to a case that I had.
Go ahead.
That probably should have done. I filed a workers' comp case. It was settled, but during the process of the court proceedings, I kept asking, I wanted my time. I wanted to make sure I had my time when I went back to work. But in the end, I didn't receive any of my time. I lost it all, but I had a settlement. Was there anything that, probably hindered from me from getting my time back?
Well, let me ask you. So I guess I presume I understand the answer to this. In your settlement, you didn't terminate your employee. You actually went back to your employer after the settlement?
Yes.
Wow, that's a pretty big achievement in and of itself. Most of the time when we make our settlements, the employee resigns from the employment of the employer. But if you have kept your employment with that employer, then that employer ought to reinstate your sick time, because the workers' compensation benefit should be a workers' compensation benefit. It shouldn't be an employment-related loss of time, which would be a reason to sacrifice your sick time. So the question is, was this an accepted work injury settlement or a non-accepted work settlement?
No, they didn't accept the injury.
So if they didn't accept anything and they just gave you a settlement, then we call that a non-admission settlement. And if they don't admit it, then it's not considered a workers' compensation claim. You just get a settlement. So in that case, you would not be able to reinstate your sick time because it has nothing to do with a work injury. It was simply a settlement without admission of an injury.
Okay.
Got it?
Yes, thank you.
Okay, thank you.
Wow. Let's talk a moment about settlements. How and when do they happen?
Settlements happen when one of two things happens. Settlement